Bill's here. He'll be starting off in just a minute. I want to request again that you don't smoke during the sessions. Also, I want to also remind you that tomorrow morning we're going to start at 8:30, both in the sidecar room and in the Webster room. And at 10:15, we want everybody in this room prior to 10:15, actually. So when Mr. Mullen and Mr. Lawn get here, we'll be good little children and be in our seats, as they say. So anyway, with that, I'll introduce you to Mr. Link from the Chief Counsel's office, and he'll probably introduce Pete Neeson. Bill?
It's thinking. It's thinking. Don't.
It's interesting.
Yeah, it's known as you put on the pressure and it disappears. Hi, I'm Bill Link. This is Pete Neesing, who will go second this time. We did the other group. He went first, so we're swapping around. But the real reason is when I finish, I'm going home. Okay, so and we're going to be through no later than quarter of, it says here. I thought I'd go through quickly to start with and tell you the volume of property that is handled, forfeited, and what have you through our office in a typical year. And when you get to the bottom line, during the last 11 months, and that's as far as our stats have gone, 11 months of FY83, we processed 25% more than we did in the fiscal year before. And the total comes out to $48 million as opposed to $38 million the year before. The total vehicles in this past year were 1,151, vessels 17, aircraft 36. What's interesting about the aircraft is the value of those 36 aircraft is $7.3 million. The value of all the vehicles put together is only $8.2 million. So all the sweat and all the work you go through on money volume of cars is almost equal by seizing 36 airplanes. So there's a trend there. The year before on airplanes, we only seized about 3.8 million, about half as many. Total conveyances at this point is about 1,204. By the time we add the rest of them up, we're going to hit right around 1,300. It's also interesting, in the last 3 fiscal years, we've almost put exactly 350 conveyances in use every year. It's been like 350, 350, and this past year I think it was 365. But it always comes out to virtually the same thing. The currency seizures were 752, and they totaled $18.1 million. Real property the past year was 47, and a total $8.0 million. Other was 131, is $2.2 million. So that's just for the purpose of giving you a ballpark of where we are, and that's our total. I thought I'd go through very quickly and hit some high points of what is coming that is going to affect what you folks do in the field. The first thing that's going to affect you, and something that you're going to have to make a preliminary determination on how to handle a particular matter, is that the Marshal Service, shortly after the first of the year, is going to take over what GSA does for us, or GSA, the General Services Administration, or I should probably say what GSA doesn't do for us. Okay, and the reason for that is the GAO study that showed that GSA is taking too long to sell property, and what they sell they don't get that much for. The Marshal Service now has the budget to put 45 people on their rolls. They're going to open up 13 regional offices with 3 people in each office. They're going to take all the property from us, administrative and judicial, particularly in the conveyance area, that we do not want to place in official use. So the burden, and the new burden, or a more definitive burden, falls to you to early on to figure out, does DEA want to put this property in official use? Okay. You have to, in making that type of determination, figure out how much lien is on that property, and is the fleet shop going to give you money to buy that 6 months down the road? Then, when you make that determination, you don't refer that to the Marshal Service early next year. You keep that, hold it, and then we put it in use, hopefully in about 60 days, or if we get a petition in 90 days. Or it hangs for the court. We send the court applications and what have you, and we probably get named substitute custodian. But at least the marshals don't have the property. We keep it. When it gets forfeited, we put it in. So that is ongoing. They're going to have a computerized system of their own, and the main thing that you have to do and know is that, number one, the system is coming. They're going to take the property, they're going to detail it, and by detailing I mean a car probably taking $50 or $60, clean it up, put a coat of wax on it, and The FBI is doing something like that right now in Richmond, and they're getting almost retail value for the cars. So that's a big difference. Pardon me?
We do it in Chicago.
You do it in Chicago. Good.
You bring a lot more.
Yeah, a little bit of fixing up goes a long way, and that's what this outfit is going to do, either by their people or by contracts in the field. So they're going to, as soon as we tell them, as soon as we refer it and say we don't want this car, they take it. Could be 2 days after seizure, could be 2 weeks. Whenever we refer them to them, that's when they're going to take them. It's not exactly clear how money's going to be handled with them, but that's one of the things we're working and resolving. We have at this point a Justice Headquarters Committee, which I serve on, people from Marshals, FBI, INS, JMD, and what have you. And incidentally, for those of you that received a memo from Don Quinn a couple of weeks ago for comments about storage of money and what have you, and comments to come to headquarters, half of that memo was wrong. Okay, it was signed by a guy named Liberati and what have you. It was a working group down below in Justice. His interpretation of what DEA's participants and INS's participants at that meeting, what they were, was half wrong. So what's in there, the bottom line is disregard that. That group is now a sub-working group under the bigger Justice Committee. So that is going to come through us, and we will have that. The bigger thing which is going to impact on you is we're looking at December 1 on moving to a floor of not seizing things under a certain value as a general standard. The floor for assets will be $1,000. So if your agent sees $462 or an airline ticket of $371, you don't forfeit it. You don't proceed with forfeiture. It's a non-seizure for forfeiture. You may have to initially take the property to protect it. You may initially have to take the property for evidence, but you do not intend to proceed with forfeiture. The floor there is $1,000. The next floor is a vehicle floor. It's going to be $2,500. You're not going to have all these pickup trucks of $600 and $700, etc. Goodbye. $2,500. Vessels and aircraft, $5,000. If it's not worth $5,000, we're not going to fiddle with it. We would have had the floor in October, but our friends at the FBI, we believe our bureaucracy is tough. Theirs is even tougher. I know, I used to be one many years ago. We tried to move on October 1. We've now slid to November 1. We've now told them we're not sliding anymore. We're going on December 1, whether you go or not. So on December 1, these floors are going in. Let me say one more thing. We're also going to apply that floor to impound releases. So if the property passes the floor, you got a $5,000 car with a $3,000 lien. The difference is $2,000. Now we wouldn't release after the December 1. We will $2,500 on vehicles. So impound release that. Don't go to forfeiture on that either. It's going to save a lot of time, effort, and what have you. Yes, ma'am.
Question I have is, are the bad guys going to know this?
The bad guys will probably find it out. There's two caveats here, and that is the SAC on DEA side. The SAC is going to have the discretion if he wants to proceed with something under the floor to proceed. In an aggravated case, that type of thing, they're using vehicles, they're using the same vehicle over and over, that kind of stuff, he can take it. We may have a prime 1980 Honda motorcycle worth $2,400 that we want for official use. He can take it. The FBI is going to put that into headquarters. To go under the floor, the FBI is going to have to go to headquarters. So those are the floors. The floor is going to apply to seizure, and then it's also going to apply to impound release.
Same figures on...
Same figures.
Okay.
Same basic
So
figures.
on vessels and aircraft, there's 5,000.
That's right. 5,000 on a lien. In the age of... This is an... Yeah, I'm sorry. Yes.
On those airline tickets, you need those evidence in court.
He said you'll take it forever.
Okay. See, you had to be listening close there. In the beginning, you may either not seize it. You may seize it, but seize it as evidence, but not for forfeiture. You may have to seize it to protect it. You may arrest a guy in the middle of Washington, D.C. at 6 o'clock at night. You can't leave the car sitting out in the street. It's got to be locked up, impounded, and then you tell him when he's released, your car is down at our lockup lot, go get it. You say, so you can't say we're not going to seize it. That's not so. The money may be held as evidence. So you've got those three caveats in that. Now, in our continuing age of specialization, the Office of Chief Counsel is going to specialize more than we do now. Right now, there's a geographic split. I handle the Mississippi River out, St. Louis, and Chicago for everything. From now on, I'm going to specialize, and for the whole country, I'm going to handle vehicles, vessels, and aircraft, conveyances. and all personal property you can lay your hands on, chemicals, equipment like that. Steve Zimmerman is going to handle all the money cases, all the real estate, and all the exotic Tiffany lamps and all that. He likes to play with that, and I don't. So we're going to specialize by that line. We think it'll help us. We think it'll help you. So if you get it, what does Zimmerman handle? Money, real estate, notes, anything esoteric or something you can't lay your hands on. Notes, bonds, all that good stuff. If you can lay your hands on it, chances are it's mine. If it rolls, flies, or floats, you know it's mine. Okay. One of the advantages there is when we get running with the marshals, you see, and to tell you how some of the bureaucracy is going here, the marshals a month ago tried to grab the whole thing. They tried to grab all the administrative functions of the DEA and the FBI, and the DEA hit them right between the eyes with a threatening memo to the Attorney General, and they retreated, and they all of a sudden they wanted to be GSA-like again, which is exactly what we wanted to do in the beginning. But that's a bureaucracy story, which is going to take too long to tell you the whole story. But that's the short of the story. So anyway, that's where we're going. And when the marshals do that, then when they come to headquarters, and if they do get betwixt and between, they're going to have to deal with one person, they're going to have to deal with me. So that's going to be an advantage. There are cases right now, 2 cases you should know about, and they concern delay. There's a Supreme Court case which says 18-month delay in filing a complaint for forfeiture in a customs case where customs told the people that they could file a petition and not immediately go to the United States Attorney. And 18 months of customs fooling around with the petition and all that good stuff, the Supreme Court of the United States said, that's okay, that's a good forfeiture. Why? Because they had reasons and they were processing the forfeiture. About 2 months ago, on the other hand, a DEA case down in Texas, they waited 6 months to refer the case to the United States Attorney for forfeiture, and he waited 7 months more to send it and get a complaint, or to get a complaint. We had a total of 13 months. The court said 2 things. 13 months is too long, and 6 months in DEA referring with no reason is too long. So the bottom line for you all is, if your agents have waited 6 months, or if you've waited 6 months, or it's fell through the cracks, or the phantom has got it, whatever it is, and if you're 6 months into it, forget it, you got to give the property back. We know what the rule is. It's 6 months. 6 months with no reason. So that's the rule. And that'll be in the next legal comment that I come out with. There's now 2 legal comments amending the asset book. I've got a 3rd one in typing. As soon as a couple of errors get corrected, it'll be out this week. So we're going to have 3 legal comments adding to that. GSA, our magical folks, are still going to be around for a while. There is a March 1983 booklet which looks like this that GSA has, and it's called Federal Surplus Personal Property Donation Programs. I'll leave it sit right there. They're hard to get a hold of. Now, that applies to the GSA screening disposition to state and local agencies of property coming out of official use. GSA cannot screen and donate seized property. Say that again. They can't donate seized property. So that is what that is about. One of the things we have in the proposed legislation is that DEA or any seizing agency under the drug laws can donate or transfer seized property to any other federal agency, period. That's going to help. It's also in there we can transfer a property to any state or local agency that has participated in the case. Last time, and that law has passed once. When it passed last time, it was we could just give them the property. The president didn't sign that because of the drug czar thing. We know what the intention of the Congress is, and it's coming. But that's the rule. If and when it passes if it passes the way it is now, it's going to be any other federal agency, and then it's going to be any state or local that worked in that case.
What about guns where nobody else wants it? We don't want to give it back to the defendant. He's maybe a convicted felon. It's under that amount of money. What do we do?
Call up his relative. Tell him you got to send in a relative to get your gun. Guns
Back out on the street?
guns are problems. The guns, number one, the gun shouldn't have been seized in the first place. In 90% of the cases, the instructions going out to the agents in the agent's manual, and within 90 days we're going to send out another instruction, and that is, don't seize guns unless you got a threat to the agents at the time. Typically, the 2 defendants are handcuffed down on the 1st floor, and the agents go up on the 3rd floor and seize 2 shotguns and a hunting rifle. You know. But anyway, that's another story. If the guns have not been purchased with drug money, to make them an A6 traceable forfeitable item. There's no way to get rid of those guns legally. You send a letter to the person who owns the gun. If he doesn't pick it up in 30 days, you can handle it as abandoned. If he's a convicted felon, he's got to send a relative. But that question comes up, and that's the way it's got to be handled. Under the proposed legislation, which again is rattling around in Congress, now the target is to pass it sometime in January or February. The floor on between administrative and judicial forfeitures is moving from $10,000 to unlimited for conveyances. A Learjet will go administrative, unless you file a claim and bond not of $250, $2,500. The limit on all other things other than conveyances, instead of being $10,000, is going to be $100,000. So if we see $78,000, it's going to be an administrative forfeiture. Golden, right? Because we're going to move those things through like zip. And the people are going to be not as prone to file bonds of $2,500. The other thing that's coming in the legislation is, instead of the money going back into general receipts, it's going into two $10 million revolving funds in Justice and in Treasury Customs. And instead of waiting to pay off a lien holder until the property is sold, with this central revolving fund, we can pay off the lien holder right away, and the car can be sold 3 or 4 months later. We can use the money from the fund to pay off liens and put cars in official use. We can also use money from the fund to pay informants, which we can't do now. So there are a lot of goodies in that package, including the forfeiture of marijuana growing lands and storing lands that are in there, and whether the growing land stays in or not is still open for grabs. But the storage sheds and what have you are for sure in there. Let me jump back to one point which is a little confusing, and that is, last time that I blanked out on this, so I'm a little better today. GSA now, if you have property that may have to screen GSA, vehicles are screened through the local regional office of GSA. All other property other than vehicles, particularly the planes and the boats, still have to come in and be screened for donation, etc., through GSA headquarters, through their what they call their central region here in Washington. So vehicles, your area, everything else back here. We're working, and it is working, on getting money deposited and back to DEA from the Marshal Service, from the United States Attorney's Office. We've got an instruction in the United States Attorney's Manual. It's taken about 9 months to do that, but that's working. And we're talking about Department Memo 207 and 21-110. Ed Foster and I we have a lot of fun with that, right, Ed? But anyway, we're getting the money hopefully going so we get it and we get the right credit. We've tried and we've sent to the field, and the other group told me they had gotten it. We've sent you the current paste up compilation of 21 and 28 CFR. What's important about that and sending it out to the parties is that if a lawyer picks up 21 and 28 CFR today, and for the next year, he's not going to see the Federal Register notices that have the latest stuff, DEA and the FBI jurisdiction in it. So he can't get it anyplace else. And it's a disservice to them to have switched it and inserted the FBI and send them the old reg. So we want to use the new regs. As long as we're mentioning our brother agency, August 1 is when the FBI starts handling their own forfeitures. If the property is seized before August 1, then we process it for them. And that's a burden which is off our back. Hopefully they're trained enough so they'll do most of their own. I know that some officers are still calling you saying, you know, Mary, how do I handle this? You know, and it's an FBI office. Be nice to them. The situation, and this is relatively new, and it comes up, and it hit me in the eyes about 2 weeks ago, and I've been doing these for a while, is that a maritime lien takes precedence over federal forfeitures. So you have to watch out for that. We had a case down in Central Florida where a ship was seized worth about $300,000. A lawyer came in, and he says, I'm not going to file a petition. I can go to the court and be protected. You know, we went round and round, and unfortunately he was right. Why? It's his preferred maritime lien. He's also right. He's going to get his $5,000 attorney's fees. I hate lawyers on the other side when they're right, because they rarely are, particularly in this area. But anyway, he was right, and he gave us a case, and Customs gave us a case, actually, but I finally read it. And it says the maritime lien has preference and the attorney's fees in it. The normal rule in 28 CFR 9, and we grant relief, no attorney's fees, no post-seizure charges. It's the exception to the rule. So that's where it is. I'll leave you with two primary things and then a couple of quick questions, and we'll turn it over to Pete. The two things that you folks miss the most, or the thing you miss the most, is the time of filing petitions. The 30 days should be, the letter and the regulation says that a petition for emission mitigation should be filed within 30 days of the receipt of the letter. Does not say must. It then says, if no petition is received, the property will either be placed in official use or sold. And then the next line says, once it's placed in official use or sold, you can no longer take a petition. So the bottom line is, the deadline date for filing a petition is either when the property is sold or placed in official use. Worst case example, you can have a final decree the 1st of October. You can come in and ask for an N number on the 15th of October. If you wait until November 1 to put the vehicle in use, so we get a petition on October 25th, it's what? Timely. Why? We got a final decree, it's been designated for official use. The issue is, has it gone in use? If the answer is no, the petition is timely. So that's the rule. The other biggest error not made by you folks is one that's now being made by United States attorneys. And that is, they think property can be forfeited any place they want to shuffle it to. That's wrong. The property can only be forfeited in the place it is physically seized. It can be moved from the Homestead Air Force Base to our air base in Addison for protection. And we tell the court we're doing that and file a little paper with them. That's true. But the forfeiture's got to take place in Miami. And I get a call a week from assistants that don't know that, and United States attorneys that don't know that. They get all upset. They claim there's a statute that says if it's brought into the judicial district, it can be prosecuted there. The problem with that is the case that backs up the statute says that means brought into the United States from outside of the United States, not hopped from one district to the other. So it's place of seizure. Okay, quick Q&As, and then we'll turn it over to Pete. He'll tell you the wonders of the pilot system. Yes.
Are they doing anything to change this where the U.S. attorneys do not move on this property until after the criminal cases and all its appeals are complete?
Part of our magic statute is a specific statute that statutizes the case authority and says you can slow down the civil case if necessary to protect the criminal case. There's case authority out there now that says it. They don't want to trust it. The new law puts that right in statute. It says you can slow down the civil action after it's started. Case authority is clear. If you're running a criminal case, that is not good reason not to start a timely forfeiture. If we don't start a timely forfeiture, we're going to be hit with our 6-month rule.
Because in Chicago, they don't do anything on any of these cases where it has nothing to do. You know,
I know.
A lot of,
I know, and a lot of them are ultimately being lost.
Yeah.
Yeah, but there's been some question about when do they have to proceed. And that is no longer a question. The Fifth Circuit case says 6 months, and the courts are going to pick that up and run.
Are you people maybe going to come out or something if we call you and set up a meeting with the U.S. attorney to explain that?
I've got a shot at all the United States attorneys in the country on December the 6th. And that's one of I'm going to hit them with this place of seizure, prosecution, and also the delay. I'm going to tell them the 6 months. I'm going to tell them the statute's coming. That'll do it.
Are you gonna discuss plea bargaining away the money?
We're gonna
Or
discuss.
plea bargaining away the car and all
Okay,
that.
yeah,
That's
okay.
all
That
important.
plea bargaining, I've already pumped that into the committee. See, the committee has got people from all over the department. I've sent all of them copies of the problem is nobody knows what the rule is.
Well, we keep changing
What
them
is the
so
rule?
much, we don't have any, same
Okay.
civil attorney doesn't do it.
I know. You see, the problem is you've got a criminal attorney handling the criminal case, and the civil forfeiture is over in another area. The Justice Department teletype from the Assistant Attorney General, which I had him send out like 3 years ago, or not 5 years ago, says you can't plea bargain it without the authority of the section in the Department of Justice. The problem is the section in the Department of Justice changed. So I've run all this to them. They're going to put it together and then put out an instruction with the current section. I just today called the gal in the Associate AG's office who's chairing this thing. I'm now sending her a paper on showing her where the confusions are between settlement compromise in the criminal division and the civil division, because half of it's on criminal, half it's on civil, and nobody knows who can settle compromise a case in the United States Attorney's Office.
We gotta send it down so we can give them our say that they never heard of anything.
Okay, well,
Yeah,
they're gonna
we have the same problem.
know what the rule is on plea bargain, and they're also gonna know what the rule is on compromise settlement within the next 2 months. So that's gonna be settled once and for all. They take me firmly believe it. You got the money thing done, you got to think positive.
Yes, sir.
Real quick, is there anything, anyone looking into the fact, we're getting, almost letters from the attorney declaring his client indigent, and,
We're looking into it, and if it's a flagrant case where we know he's not indigent, then we'll say no. But the practical rule is it'll take longer to do an investigation to find out if he's indigent than to pay the $250. In 2 or 3 months, it's going to be $2,500. And
Well,
and the
that'll probably
indigent,
we'll probably get more of it.
well, but then we're gonna look at it again and see where it's going. But that's, you know, there's a case that says you've got to give the poor person his shot, and you can't get around that. So.
You didn't happen to look at that one.
I've got it today. I just got it.
Did you say what?
I see exactly what you're saying. I haven't figured out yet why they did that, but I'm going to get to my form, folks, and find out what's going on. They've got a form, the Declaration of Forfeiture, which now at the top, amended in 1981, is when the date on it is, says vehicles. I don't know what they're using for things other than vehicles, but I'm going to find out exactly what. Okay, before I leave and turn it over to Pete, let me tell you that as far as what he's going to talk about, the pilot program and what have you, I was so negative on this program that I was deliberately, by my desire and the higher ups authority desires, separated from this program so I wouldn't mess it up if it was going to work. Right. It turns out that it is going to work, and it's going to work well. It's going to be a positive thing, and it's going to end the most frustrating thing for me, and that is, and hopefully for you too, and that is when the Phantom gets the file and you can't find the silly thing. This machine will turn out and redo a file. You push the button, here comes the file. It doesn't matter if the Phantom can have it and running with it. Pete can make a new one. So he's going to tell you how to do that. And as long as I've been doing these things, if I'm convinced it's going to work, then hopefully he can convince you too. Nice seeing you. Peter Niesing, Pilot Project Extraordinaire.
Adios, sir. Well, good afternoon. It's late in the day. I'm sure you'd all rather be somewhere else than sitting in here. I'd like to open my remarks by making 2 comments. One, there was a discussion in the Monday afternoon session about Pathfinder and the various divisions. As I understand it now, there are 3 divisions without Pathfinder terminals hooked up. Those 3 divisions will be online by the first week of December. There are only 3 divisions without the system. Yes, there was a problem with the telephone company and installing the lines down in the DC area. It was only last week that the telephone lines were turned over to DEA for implementation. So you will be getting a contact from operational support on getting those items in. Secondly, the system that I am going to describe to you is a system that we envision in operation nationwide. And the procedures that I am going to discuss with you very briefly are the procedures that we see going in use nationwide. There are still some problem areas that need to be worked out, and there still needs to be an understanding between various sections in headquarters as to what kind of information will be provided by this system, how it will be reported, when, things of that nature. When the program comes into your division, you will know what's what, and you may be required to operate a dual system for certain information. We will work that out by the time we get to you. So please understand that what I'm telling you now, there was some misunderstanding in the Monday afternoon session. They seemed to think that what I said was going to happen almost immediately, and all the forms that we're talking about eliminating are eliminated and things of that nature. They will be, and hopefully 1 year from now, we'll have this system running completely. The system, we had anticipated Mr. Mullen approving the system today. He was given the memorandum to approve it on Tuesday, and there was some discussion on it yesterday, and we just haven't heard on it, so it's very soon. What I'd like to do is open with some brief comments as to why and how we came about the computerized asset system. In the summer of 1982, in response to JMD and GAO studies, DEA decided to review how it handles asset forfeitures nationwide, system-wide. And we found that there were many vulnerabilities And some of the problems were that there was an excessive field workload. There were long and costly periods of storage. We had various types of unused ADP resources, and we had assorted problems attributable to the lack of policy guidance and management control in headquarters. We had 3 different units responsible for reporting various types of assets. We had the Office of Intelligence, who was responsible for reporting agency statistics. They had the most comprehensive records on asset records for the agency. And their collateral duty was the receipt of the 440s from the field and inputting those items into the system. However, they lost their quality control early on, and the study team found various errors. For example, we had a $6,000 tractor in the system as a $6 million tractor. We had a $10,000 Corvette listed at $1 million. So you can see we had some problem on how much DEA seized over a fiscal year. We also had the problem of referred assets to other agencies being counted as DEA owned. For example, in the Marathon office, we found out by the 440 reports that they had 16 vessels under seizure worth $1.5 million. And we said, wow, we want to see what kind of problems they're having with those vessels. So we contacted Marathon office, and they said, oh, those vessels. Well, those vessels were turned over to the customs to process, and we handled the defendants. So DEA actually referred that asset. It was not a DEA process seizure. So right in the Office of Intelligence, we saw some problems. Then in the Office of Chief Counsel, and had the authority in handling administrative forfeitures as well as providing assistance in complex judicial cases, we found a manual file system on all 881 seizures. They had fairly accurate records, although 28% of all Chief Counsel's records were missing. So then we come up with a discrepancy between how much was being reported over a fiscal year by the Chief Counsel's office as seized assets and how much was being reported by the Office of Intelligence. Intelligence was reporting $70 million for FY82 and Chief Counsel was reporting $38 million, a real difference. And then we had the Office of Accounting that had established a computerized system for recording seized and recovered monies. At the time of the study, we found that there were 2 divisions that never put any entries into the system. And of the three other former regions that we looked at, only 60% of their information was going in. Now remember, this is 1982. And we found that there was no cross-checks of these systems, there was no methods of tracking the assets from start to finish, and there was no way of comparing the expenses with the amounts deposited to Treasury. So we came up with some conclusions. There were no accurate statistics, there was no program control, there was an increased workload on the field with increased responsibilities, with no help coming out of headquarters. It was taking 3 to 6 months for assets to be referred just to headquarters. And we found that the agency itself was losing money on any kind of conveyance seizure less than less than a value of $2,500. For example, in one division, we found a car valued at $50 that was seized. And it had been in storage for so long, the expenses amounted to $3,000. So you can see at that point, it was, DEA was in the red at that point. As well as there were no policy guidelines and there was no assertion by DEA in any interest in assets except on the field level. So the recommendations were made by the Office of Planning and Evaluation to design a system that would ensure accuracy, accountability, that would control the asset process, and to give disposition directives. Now the system was established based on the Pathfinder computerized system. Pathfinder was selected because it's available or will be available in every divisional office. And it will be important for the field to input seizure data into our system by using Pathfinder. We also saw that the field was using 5 different types of forms to report asset seizures. And you know what they are: the 23, the 7A for seize and recover monies, as well as other financial instruments, the 6 for reporting probable cause, the 425 for seize and recover monies, and a 440 for handling assets removal. We looked at every form, and we decided that it was important to come up with one form that could handle everybody's needs. And we did, and it's in your brochure on page 8 is DEA Form 453. The 453 has been designed to eliminate any typing. It's to be completely handwritten and to be turned into a divisional input operator for entry into the system. The new computerized asset program transfers all administrative authority for assets from the field to the to headquarters, the asset forfeiture unit that has recently been set up. Can you hold your question, please? The asset forfeiture unit will be responsible for handling all the notifications, all the advertising orders, all the referrals to U.S. attorneys, any referrals and applications to GSA. We will keep track of the assets while they're in process, and we will make sure that the asset is disposed of properly. We also intend to evaluate each division and to determine specific disposition alternatives, working with the various U.S. attorneys' offices. Now, we decided to test this program in the Washington Division, and it was started in January of 1983. We had some problems in the beginning, especially when it came to the probable cause, because we were looking at abbreviated probable cause rather than volumes of 6s. We're just looking for the basic who, what, when, where, and how. And it took some getting used to. We also had a problem working with the U.S. attorney's offices, but we finally got them to agree that the computerized printout that the system will provide will be acceptable in court. Starting on August the 15th, the system expanded to the Miami Division. The Miami Division is accountable for almost 50% of all of DEA's assets seized in any one fiscal year. And we felt at that time that if we brought the system into them, that we would be able to determine any problems by the time we were ready to go nationwide. And we've been working well with them. Just briefly to look at this little handbook I put together for you, I have several examples of the different types of assets that can be seized, handwritten in there, also with a copy of the form. The form is using coded information that will be found on the reverse side. The agent just fills in the blank. Once the form is filled out completely and it has been approved by the supervisor, it will be turned into a divisional input operator for entry into our system. Once it's in, your work is done. The only other thing that you will have to do is conduct petition investigations when necessary, and to dispose of the asset, to maintain custody and control of the asset and dispose of it when directed by Chief Counsel. I should also tell you that the form, when it is published, will be in 3 parts, and it will be also used as a receipt. So a custodian will get a copy of this, and a copy will go into a case file, agent's case file. The agent will also receive a copy of the hard copy of the printout from the system once it's verified and it's input. At any time, a division operator can call up a particular record and can give you an idea of what's happening on that asset. As I said, all management control will move to headquarters. However, at this point in time, there will be no staffing changes in the field. I don't want to take up too much more of your time. As I said in the beginning, we're in 2 divisions now, and we're still working out the bugs. And I don't envision moving out into another field office for another 3 months. Now, when we come to your field division, you'll know it in advance. And the team from the asset forfeiture unit will go and talk with the SAC and the administrative people. We'll work out the details with the various U.S. attorneys' offices. We'll work out the details with GSA, the Marshal Service, if their system is up and running at that time. And then we come into your office, conduct training of all personnel. We also do historical recovery of all the information that you have on open case files. Because when our system is up and running, we will be responsible for the management of all your assets. And will be responsible for trying to close out your assets that you have lingering for many years. That's basically it. The handbook here will provide you some data, and when the system is coming to your area, you will certainly receive much more. Questions? Yes.
Yeah, on advertising, you're going to do that, right?
Yes.
Okay, what about, that's not gonna be charged against our operating funds, that's all be charged from insurance funds?
The office-
Getting billed from the state.
The asset forfeiture unit will be budgeted, and we will have our own account to maintain. Bills will come directly to us. We will verify those bills and send them on to accounting for payment. The petitions, if there are any claimants made, those petitions will come directly to the Office of Chief Counsel. We will review them and decide whether they need to be investigated. If they do, they will be sent out by memo to the appropriate office.
We'll still be responsible for storage.
Yes.
We have to bill.
As far as I know, the billing for that type will still come out of the division pocket. There was some discussion as to trying to establish a really uniform system where the field offices would have to come to one unit in headquarters to get all that money. And we found it was just too unwieldy. And it was probably better to keep that out in the field. And that's it. It's a very, very nice system.
So the headquarters now can storage.
Okay. That should conclude. It's now almost 5:45. Adios, folks.